morning, everyone.
Morning.
So, how are you today?
Good.
Good. Okay, actually, thank you and welcome to my estate planning workshop. Actually, my name is Yunif. I'm actually very excited to can have the opportunity to share with you all how to actually plan your own legacy. Okay, I've been helping individuals, especially families, okay, to create their own comprehensive estate plan. Okay, for the past 8 years, to ensure that their wishes are honored and ensure that their loved ones are taken care of. Okay, so this is my profile. Okay, nothing much. Already explained. You can treat estate planning, right? Oh, before that, I want to ask you, how many of you have done your own will?
Yes, I did.
Yeah, good.
No.
No? Oh, so you're coming to the right workshop, right? Okay. So for Elizabeth, you have done your own will, right? So besides will alone, have you done any trust?
No, not really.
No,
Just a simple one and long time ago.
Just a simple
Yeah.
will, right?
Yeah.
Okay. So you're also coming to the right workshop today. Okay. So we'll share with you at the comprehensive estate plan. It's not only for will alone. It actually covers many things that we will explain later. Okay. So you can treat this estate planning as a very fun workshop. Okay. Just treat yourself as a master chef. Today you're a master chef. So okay, your life is actually your secret recipe. Okay, that you have been perfecting for years. So your ingredients will be your home, okay, your valued possessions, and also your family members. Okay. So what if one day you're not there to stir the pot? Okay, how can you ensure that your recipe is passed on and also your enjoyed by your future generations, enjoyed by your family members? Okay, you actually can treat estate planning, right? It's like kitchen toolkits, your kitchen toolkits, okay, your utensils. So for the view itself, it's actually your recipe card. View is only your recipe card, and you are appointing an executor for your view. So you are appointing a master chef. Okay, so you also can appoint a trust. Okay, your trust will be your secret sauce. Okay, so today we are going to discover how to let this your secret recipe, your secret sauce, your ingredients, everything, okay, to pass on smoothly to your next of kin, to your beneficiary. Of course, during this workshop, we will add in some dash of funds, okay, some sprinkles of practical advice, and also a mixture of some interactive discussion, so to make these events interactive as possible. Okay. So let's put on your strap hands, then we'll start cooking. Okay, but before that, we will actually look at the objective today. What can you get from today's session? Okay, of course, basically we can understand the basic fundamental of what is an estate plan, and we will can differentiate between the will and the trust. Okay, how does it take effects? Okay, how to protect your beneficiary interests. Okay, and avoid common pitfalls based on real case scenario. And at the end of the session, you will know how to build a solid estate plan. Okay, cool?
Good.
Yeah. Okay. So this is the content. Don't take seriously on the content. So we will go in one by one. Okay? So basically, we will see. When you talk with people about estate planning, when we share with your friends or we share with your customer or something, okay? So what is their main reaction to you? What will they react to you?
Try.
Try it. Yeah, any?
Like cursing them.
Like cursing them, right?
Still got a long time to plan.
Still got a long time to plan. Did they say any negative things or estate planning? I do not need. Or something like that, okay? So basically, today I actually sort out, there's many misconceptions about estate plan. So I sort out the top 5 misconceptions, okay? So the first misconception we have is estate planning is only for the wealthy. Normally, when we talk about estate plan, right, they say, I don't have so much money, I do not need to plan, okay? So in reality, even the modest wealth that you have, right, you still need to plan. Why? Any Anyone know why? No, okay. Because basically, normally for human being, our perception is very wealthy lah. I don't have assets lah. Normally my client will say like that. I don't have assets, I don't need to plan. Okay? But I will tell them, okay, I will ask them some questions. I say, everyone will have your own very special wishes. That not everyone is the same one, correct? So everyone have a family to take care of. True?
Yeah.
Everyone, if let's say you have kids, right? Even you don't have money also, you still want the best to give to your kids. True?
Yeah.
In the event of incapacitated, right? Everyone wants to be treated very well. Correct? You send that to government, they say, hey, government, no money, I don't want. Okay? They still want to treat the best. Okay? So this is estate planning. So basically, estate planning, a true definition is that you are not actually distributing your wealth. You are actually distributing, giving the security, giving certainty, and also giving peace of mind for yourself and also for your family members. So I would summarize as estate planning is not a luxury. It's a plan that everyone needs. Okay? So second misconception that people will have is that estate planning is very complicated. You tell me to do estate plan, wow, very costly, complicated. I don't know where to start. Anyone have this perception?
That's why I never start.
Yeah, you ask them to start, I say, hey, 麻烦 I don't want to start first. Okay, because I don't know where, complicate. But if let's say today I ask you at this moment right now, can you actually list out for me how much your asset and your liabilities for you yourself? Can you actually give me one Google Drive, state down your assets, state down your liabilities immediately? If let's say you yourself also cannot, right? How do you expect your spouse in the event you don't state this one inside your will, okay, or inside your trust, you don't list it out? How do you expect your spouse or family members to know? If let's say they don't know, right, it will be more complicated. For you yourself, you will be too complicated. I want to do it myself. I ask you today, within seconds, you let me know, or within one day, you let me know your total assets, total liabilities. Also, you cannot do it. So you cannot expect your family members to do it for you. Okay? So it will become more complicated if let's say you don't have an estate plan. Okay? And then people say that it's costly. Okay, so if let's say same thing, today you don't have the list of your assets, the list of your liabilities, right? People going to search for the list also takes time. So it makes things, the time will drag and it will cost a lot because you got to find lawyers, you got to find agents to do it for you. Okay? So third misconception, I'm too young. People say, how are you? Hey, you asked me to do will. I only right now start to work. Should I? I don't think I need so much because I'm still very young. But look at these articles. You see this one, we don't focus on who is it. This one pass on at the age of 25. Okay? Pass on at the age of 25. Okay? So this one I think some of us will know, right? 4千金, one of it. Okay? This past one actually suddenly, okay, at the age of 37. This one is one of the company director, also passed on at the age of 37. Okay, this one, because of cancer, passed on at the age of 14. So young. So is this statement still valid? If let's say I say, I'm too young? Because in reality is that accidents, unexpected events happen at any age and happens at any time. It's unpredictable. If today we don't plan earlier on the last wishes, we don't plan it down, so it will be difficult and complicated for the family members. Okay? So the fourth misconception is that they know sometimes this one happens to those who is aged. Okay? You go and tell them, they say, oh, verbally I told them already. I said, hey, this property I already told my daughter verbally, I want to give to my daughter one. Don't need to write. This bank account, can one. I already tell them, if let's say in the event I'm not around, they will go and withdraw. Because I have the password, everything, they can withdraw from it. They knows, okay? But in actual fact, as a valid bill, we have to pen it down, written it down properly. Okay, it's not verbally. Verbally is not recognized for Malaysia. Okay, later we will see what is a valid bill. Okay. So number 5, people like to do DIY. We ask them, do bill? They say DIY cannot. DIY, no doubt, you can do for very, very simple bill. You want to state down how much property you have, how much asset you want to give to who. That one, simple can. But as I said earlier, when you plan for your estate, it's not only planning for death, you are planning for incapacitated, you are planning for long term, maybe for preservation of the wealth. Okay? These kind of things, future planning, very extensive planning, DIY may not be suitable. Sometimes DIY view, even the most simple one, can invalid your view itself. Because if let's say you don't know how the procedure to do it, then it will be, when you open, it cannot work on my view. Because I've lack of executor, I didn't put, or the beneficiary where I put, I don't have substitute beneficiary. So it becomes invalid. Yeah? So any questions on this misconception, everyone? No, no question, Okay, good. So we continue to what is estate planning. Okay, just now we go to misconception. Right now we continue on what is estate planning. Estate planning, actually you can break it out to 2 parts. Estate, which means what are the things that we own? We own properties, bank account, business. Okay, some businessmen, they have business. And then we own jewelry, or some have other collectibles. Is all our assets. Okay, planning is when the estate we want to plan, how we want to plan, how we want to organize. Okay, and we want to preserve, we want to pass on, how are we going to do it to our next of kin. Okay, this is what I will define as estate planning. Okay. So, I actually sort out estate planning. A complete estate planning shall have a 4W1H approach. Okay, or maybe let us just click on this. Can you see the video?
Yes.
Okay, so actually I sort it out. If let's say you want to write an comprehensive estate plan, so basically people will say, oh okay, I already write a will, I wrote a will. So basically my estate plan is enough. Okay, but let us scroll down in details. First, we look at the approach first, then later we look at some real case scenarios, then you will know whether estate plan is it only view alone. Okay? So you see, the first W is who ma. Okay. When we write a will, right, we actually need to state who are our beneficiary, okay? The asset we want to give to who. Correct, huh? Okay. So the second who is that appoint the executor. Executor is the one who help you manage your estate, clear your debts, and then distribute. Okay, who do you want to give this master share? Okay, to who? Third one, if let's say today you have a children below 21 years old, you need to appoint a guardian. Number 4 is attorney. What is attorney? Because for an estate plan, right, normally people will plan only in the event of death. Okay? But estate plan also can help you to plan in the event of incapacitated. That means in the event you no longer have the capacity to take charge of your own assets, to take charge of your own liabilities. Then you have to pass these rights or this task to an attorney. We call it, we transfer the power of attorney to others, okay, to those trusted entities to help us continue to manage these assets and liabilities. Alright, this is the first rule. So you see, this one I scroll down into executor. Appointing an executor is that appointing who do you trust to manage your assets. So this is some news article. You see, elder brother transfer shop in the house of his name without following his father's will. Dishonest uncle plunder his niece 70 pound inheritance. So these articles actually shows you it is important to appoint your trusted executor. So executor we can differentiate into two parts. One is that either you appoint individual executor or either you appoint professional executor. So what are the differences? You see, when you take up the job as an executor, right, it's actually a very tough duties. Okay? So what are the things that most people are looking for when they want to appoint as an executor? First, whether you can commit on the time or not. Because why is it important, you see, when you become the executor, as I say, you will need to settle their debts first. So what kind of debts that we have? Normal debts we have is mortgage, correct? Mortgage we have, and then we still need to clear our income tax clearing. Okay, these two is the main one. But take an example. Today you go to bank, you as executor, you go to bank, you say, hey, I want to close this account, I want to take the money as an executor. Then the officer told you, document I want A to Z. Oh, I left out document F. You go back and take up. Then come up. Cannot, this one document no one can. Cannot. Sorry, we now want to pull out. Cannot. So you have to go back the next day. You come back. He said, oh, next day or next few days you come back. The officer said on EL. On EL. No officer, other officer to in charge. No. You come back because this officer is the one in charge of the case. We don't have other officer to take charge. Okay? This is the commitment that I mentioned, the time required. And then imagine this, when you appoint this executor is not the one that nothing to do one. Maybe they have their own job. Every day they still need to work. If let's say this bank account, the officer also need to take so many leave. So you imagine how many times he need to commit to settle just the bank account, to close the bank account. when you appoint executor, you need to know whether this executor can do this job or not. Their time, is it committed to do so? Do they have time? Some of my clients, right, he appoint his daughter, but his daughter is a doctor. So doctor, as we all know, very so busy. They don't even have the time. If let's say you ask him to run here, run there, just for the closing of bank account, just for the clearing of mortgage, do you think he or she can do it? Cannot. If let's say right now you already know that they cannot do the job, why not you just transfer out this job function to others? Okay, rather than stick back to the one that you want them to do. Alright? So second thing, have the knowledge and also information. That means, do they have the knowledge to do the job? Because as an executor, before you have to know what knowledge, deal with the mortgage officer. Okay, what are the documents that you require to bring along to ease your time? No need to run so many times. Okay, because everyone is doing for the first time. Not executor job is not like you're buying things or you're selling items, right? You do it so frequently. Executor, the best no need to do lah. When you become executor, that means either your family members are already not around, so you have to take up the job. Okay? So this knowledge is you have to pick up on the spot one. Today, if let's say you're individual executor, or maybe, okay, this mortgage or maybe we go to income tax department. Income tax department, lucky we don't know what they are requiring. So the first round we go there, we have to ask them, what document we need. Second time we go there, document not complete. Another officer said, you want to add in a document, and you go there another time. I said, hey, you need to compile the estate, the income tax, all the details. You need to do accounts. You need to do closing. Income tax closing. How? I need to hire accounts to do it for me. So extra cost some more. So this is the hiccups that when individual executor have. But if let's say you have your appointed executor know how to do this job, no doubt you can go ahead for them. Okay, to choose your individual executor. But this is the knowledge that they should require, they should have. Alright? So the third one will be have sufficient legal, that one's also financial knowledge. Okay, this one we see manage expectation of the S and also the beneficiary. Sometimes when you become individual executor, let's say siblings, among the siblings we have 4-5 siblings, 4-5 beneficiary, and then the disease appoint one executor to lead the show, to distribute to all the 5 beneficiaries. Okay? But this individual executor also have their own job to do, their own work to settle. He may delay. See, today I don't go because I need to handle my personal things. Okay? I don't have time to go. So drag on. So drag. Within the sibling said, hey, you want to do a job or you want to do? Why is it delayed? I did the money. So you don't do? So how? Then there will be argument dispute within the siblings among themselves because of dragging. Yeah. So file tax return I already said. Okay. Pay bills. Pay bills is considered mortgage, income tax, or what other bills that you have, credit cards bill. Okay. So this is other things. Okay. So up to the job is that people when they choose executor, normally they want to look for those trustworthy. Trustworthy, why is it trustworthy is important? Because when you appoint an executor, that means you are giving all your rights, giving all your assets, okay, in the hand of the individual executor first. Okay? Because why? They have to pay the debts, so they have to get hold all the liquid assets, all the illiquid assets before they can distribute. Okay? And then what if you appoint this executor, the asset that you are giving is to your children below 18 years old. Then they have to get hold of this property in their hand first. Okay, do you know what can we do with the property? In the event, because executor right is so huge, in the event in between, these children need education funds. Okay, age 15, 16, they need to go university. Okay, executor can actually have the rights to sell off this property and give the education fund. So when the children already can inherit, which is at the age of 18, no more money already. Because why? The property already sold off. So trustworthy is very, very important. Okay. Second, the financial skill is what we are looking at. Skill and knowledge. Objective of fairness, same as this one. Okay. Organization skill, health and longevity. Want to focus on this. Health and longevity, that means for individual, normally age until how many years old? 80 years old, 80, 90. When you appoint an individual executor, you have to take note on the longevity. If let's say today you only age 40 years old, and you appoint an executor, this executor already age 80. So at the point when the demise, okay, this executor already how many age? Maybe 100 years old already. So do you think he still can do the job? Cannot. First scenario. Second scenario, when you appoint individual executor, this executor, when he do halfway, pass on. When he pass on, then everything have to restart again. That means we have to go to apply the probate again, apply the LA again, because the executor no more around. So everything have to start. But before we reapply, we have to make sure this executor also have their own will. Have their own will, and then the asset that is he actually on hold for the disease, right? He actually did separate it out. For example, if let's say he on hold on the bank account of the disease, and then halfway through, before he distribute, he only clear debts, but this money already inside his own bank account, he pass on. So we have to wait until this part, he going to segregate what is belong to the disease, what is belong to he himself. Only then we can apply again the probate, the process. So this point a bit complicated, okay? But the point that I want to mention is that it will take time and it will delay. Okay? So back to next now. So I will compare as an individual executor or professional executor. When you are choosing an executor itself, okay, trustworthy is the most important. Okay, trustworthy whether existing right now he have financial pressure or don't have. But if let's say right now he don't have financial pressure also, we do not know or we cannot assure in the future whether he or she have the financial pressure. Okay, is it her full time? Full time is very important. Otherwise you cannot run here, run there to settle all the things. Knowledge, impartial. Don't side one of the parties. Sometimes he side either one of the beneficiary. He will say, okay, you pick first. So do they have a systematic account? Sometimes I don't know whether you all will face when you talk to your friends or something. The account, the disease estate, maybe 1 million. Bank account, liquid asset 1 million. When to come to beneficiary, right? Why 500,000? Yeah. What happened to the other 500,000? So if let's say individual executor, let's say this executor is one of your siblings, one of your family members. Do you ask for statement of account? You ask, very good. But
You have to justify how come become no more half of it all.
Yeah, true. You can justify. But once you come up with this statement, right, how will the executor or your siblings feel?
Not trust me.
Yeah, no.
Obviously, that's why I asked for the statement.
Yeah, when you ask, you already know that the executor will say, you don't trust me. I want to pay that from my fees. As an executor, I run here, run there, no need fees. So basically, maybe the fees of 50,000, you take 100,000. Because an individual executor, for your information, they can take up to your estate, the estate of 5%. total asset of 5%. They can ask from the court, they say, hey, because I become the executor, the job is so tedious, then I request for 5% payback of my salary.
They can just take on their own.
Executor can just take, because the money is on the hand of the executor. They want to take. And like even say, whether you want to ask for the account or not, it's just that you can ask for the account, but when you ask for the account, then there will be dispute, disagreement, okay? And then not trust here, not trust there. And then the family ties will like untie just because of money. So if let's say family want to avoid these kind of things happen, whereby we can ask, but it's not that not right to ask. It's just that when we ask, we already know the consequences that the family ties will not be that strong anymore. Because you are questioning their capabilities, you are questioning their trustworthiness to ask for it. And then for individual executor, normally they don't provide or they are unable to provide this kind of information. But if let's say today you appoint a professional executor, you see the difference, all the siblings, they say, hey, we ask, because this is a third party. So we can actually, the family can tie together. They say, we want the account. We asking from the third parties. So it won't affect the family bonding. Because we are asking for third parties now. So the third parties professional, normally they will have, for sure they will have this accounting system. So they can let you know how much that they are giving to the debts and how much left. So this one just now I mentioned, will actually the testator, the executor that you appoint actually outlive the testator. Either it's halfway through, he pass on, then it will be a bit mafana. Okay, so in this point, I'm not saying that you cannot appoint your individual as an executor. When you are appointing individual as an executor, you have to know whether they can fulfill this requirement. If today you are only giving out a simple bill, a simple distribution, and your beneficiary only one or two, the assets only very simple, like bank account, property also free from encumbrances. Okay, I do not have business, jewelry, I just pack it one pack, ABC, define clearly. Then, yeah, you can appoint your individual executor because there's no extra charges. But if let's say today, your estate, right, your assets, you have many properties, okay, you have business, you have so many bank accounts, so messy one, okay, and then you want to give to different beneficiary. That one, maybe you have to see whether they can do this kind of job, okay, or whether they want to do it or don't want to do. If not, then it's better for you to hire a professional. Okay? Any question?
So you mentioned the executor is like the daughter as a daughter, not free executor, right? Then can she get a lawyer or representative to do like a running?
Can. He can appoint a lawyer. That means it costs already, it costs extra. He can actually appoint. So normally, when people appoint individual as executor, normally they don't do the job one. They still appoint the lawyer to do it for him, to run the show. So when they appoint lawyer to run the show, might as well today you hire professional, then this professional help you to do everything. Because lawyer also they charge, professional also they charge. Why not you already know he or she don't have the time, you just appoint professional will do. So what your daughter need to do is that, choose the executor, choose the professional team. Where you want to release the money, at what stage, right now. So, you need to mafana. If let's say you know, right now she already don't have time, she also will hire a lawyer. And the lawyer charges is uncertain. We do not know what is the lawyer charges. Some, they will say, won't charge you free. But upon demise, the bill come out already. No free one, no. You still have to pay these charges. It happens happens actually.
Are they subject to maximum 5%
Yes,
if charged by lawyer?
because individual executor.
Oh.
And that one individual executor, sorry, but for lawyer because they are not executor, so their charges you don't have a set of condition or set of fees. We do not know how much they charge. Normally they will charge based on property size, your wealth size of your wealth, whether how complicated is this case, and then they will charge accordingly. They don't have a set of fees. But if let's say today, for example, for rock bills or for public trustee, any trustee company, they will have a set of fees that you know upfront. How much I'm going to give. Okay, if let's say I appoint professional. But if you appoint lawyer today, later on, you appoint individual, lawyer, individual executor, then this individual executor go to appoint lawyer. Then this lawyer, they will say, hey, the wealth, 10 million, 1%. 2%. They charge based on their own discretion. There's no set of fees that government has set for them. But for professional like trustee companies, they do have this set of fees. So you already know upfront what are the fees like. Yeah? Any more questions? No, okay. So now second, what? Just now is who are we appointed, and then we focus on the executor because the executor point is very, very important. Okay? Second, normally what people will only look at what are my assets. Okay, you list down, okay, what are my assets? I have property, I have bank account, unit trust, investment, I have jewelry. Oh, this is all I want to distribute only. Then, what are your liabilities? Do you know liabilities also important when you are making an estate plan? Why is it important? Why is it important?
You come to claim.
Okay, we look at this chart, right? When a person passed on, the asset all frozen. This one is no bill lah. Okay, we go for the bill. Okay, because basically it's the same, just that this two parts will be different. Okay, so we look at when we apply for grant of probate, we need to collect assets, and then we need to settle debts before the distribution. So that is why I say, when you plan for what are the items, instead of planning what are the assets that we have, we also need to plan what are the liabilities that we owe. What liabilities that we have normally? Mortgage. Mortgage is the, everyone have mortgages, right? Okay, most of it have mortgage. Mortgage is the one that we need to plan because if let's say this mortgage, you don't have, in the event, past 1 month, so we have these liabilities. If these liabilities we didn't clear out, we cannot distribute the assets. We cannot pass the name, transfer the title to the beneficiary. These assets have to be cleared. So it's very important to actually determine what are the liabilities that you have. And I put it here special bequest. Special bequest, for example, special items. This jewelry, this collectible, the watches. Particularly, I want to pass to A1. This is special bequest. Or these drawings, Mona Lisa portrait, I want to pass to ABC1. Or I only kept on behalf only in my house, but this one is belong to ABC1, so I need to list out. So this is basically the assets and liabilities that you have. Liabilities will focus mortgage. We have to make sure the mortgage is all cleared. If let's say not clear, right? Okay, we have to make sure when we do the estate plan, we have to have the liquidity or enough cash to cover up the mortgage. This is to ensure when we come to the distribution part, it will make the beneficiary get the asset faster. If let's say today we stuck at the liabilities, we are unable to clear the mortgage because we don't buy any MRTA, any insurance to cover up, then the beneficiary don't have the ability to reload the things, to take alone, then it will be a problem. Then you will start. So you will see some of your, maybe when some of my friends, they say, the distribution even bill per view also very small one. I say, why? Loan haven't settled. Loan no money to settle. Because they didn't plan accordingly. So when we are doing a comprehensive estate plan, we have to plan ahead. List down the liabilities that we have, okay, and then we cover it up using insurance card, using your cash, either way, okay. It's just the main purpose is to cover up so that the beneficiary take the estate in a smooth and faster manner. Credit card, most of us have credit card. So this is what we plan, what are the assets, and also what are the liabilities. Okay? So the third one is when. When are we going to distribute? When today, if let's say you are doing just a will, okay, you are distributing immediately. You don't have a control, say, hey, I want to distribute, don't want to distribute immediate cannot. Will is a direct distribution. Okay? But in the complete estate plan, you can plan either three options. Either is immediately, or you want to give them at certain age. Okay? Today, my wealth, I have so expensive wealth. Okay? If let's say my 10 million, I give them one shot. No need to work already. So the one, I give them certain age, bit by bit. At the age of 21, maybe I give 10%. I scroll out until age 50, only give all. Cannot? Can. Okay? Or I give them over a period of time. That means today, I'm not give them at certain age, but a period of time. Period of time is that when upon demise, every month I give 10,000 are enough to use already. Can or not? Can be done. But this one, you are not, will alone or DIY will cannot use already. Because you have to really appoint professional to do it for you. Okay, but this can be done. So the fourth W is where. Where is the assets located? Either is located locally in Malaysia or is located internationally. Many businessmen especially, they have bank account or they have property maybe in Singapore in Thailand in Hong Kong China That one, if let's say the beneficiary do not know where to trace, do not know they have property there, then it will be a problem. Where the location of property. Second is, where do you locate your will? When you write a will or when you write an instruction, you build your estate plan, you need to let them know, let your beneficiary know where is your estate plan. Correct? If let's say you don't let them know, you write already, you put it under the table or you put it somewhere also, you own self also cannot find, then you can treat it as no will as well, as good as no will. You let them know where you keep. But don't keep in safe deposit box. You know why?
Very safe,
Don't keep in safe deposit box. Because safe deposit also you need to go to bank. Bank trace your own account to open. Because under your own name, need to apply probate first before you open. So how to open it? Start already.
Unless it's a joint account. If it's joint account, the other surviving spouse still can.
It will still depends on whether house when he open the safe deposit is either 2-party go or 1-party go can. Depends on how he design things. If let's say either party also can open, then okay lah. Second thing. And sometimes even the house safe deposit box he own self, the deceased own self know the number, you know. Don't let the children know the number. How to open? Go and explode the whole thing. Even the bill also get exploded. No use. So you have to know when you write an estate estate plan, might as well you know where to keep it safely, okay? Avoid from flood, avoid from fire, or so the last one we see the how 4W1H approach one. So how is that your distribution method? So how you want to distribute? You want to distribute it by way of will or by way of trust? Trust can do this job. Certain age or a period of time for trust. Okay? So a good estate plan can be able to minimize your tax liabilities. It's not to say that we avoid tax liabilities, it's just that how we are going to minimize and restructure it to be cost efficient, to be tax efficient. Okay? So a complete estate plan also be able to serve incapacity planning. Because today, when we want people to execute our estate, first is that pass on. Okay, you might as well pass on now. So people need to manage our estate. But in the event, not that bad. Just do not know how to handle. Why? Dementia. Okay, first thing we do not know how to handle. Mental incapacity or physical incapacity, TPD. We do not know how to manage our own estate. And this estate mainly we say bank account or business. So if let's say we don't do this planning of transfer the rights, transfer the power to other person, so this bank account and also business will get stuck. Okay, in the event of incapacity. Because incapacity, bill also cannot open. Why? Because bill only activate in the event of death. But what if today not death, only incapacitated? So we also need to plan in the event of incapacitated. And also for those like doing business, okay, we need to plan how the business succession will be. Mainly we plan that who will be your next leader. If let's say this businessman or businesswoman no longer around, who will be the next to lead? Okay? Appointing a business successor is not like appointing, just like appointing business successor, appointing master chef, right? It's not that one day you can teach all, then he straightly know how to do it. Like you want to become a master chef also, you need to from zero start, cut the veggie first or go and pick what kind of veggie choose veggie, how to choose veggie, how to pick veggie, how to brush your veggie, everything correct? Before you can become a master chef. Same thing. When you decide who to lead for your business, right? You also need to step by step teach them how to do it. If let's say today you just say, okay now I'm not around, my son take over. But you didn't groom him from the start. So he or she also do not know how to take over. Okay? So, any questions? No? Can I continue? Now, storytelling already. Okay. So, first story I want to share with you. Okay, first story that come into my mind is this one. The legendary Queen of Soul, Aretha Franklin. Who know what happens to her estate? You know? Okay. So Aretha Franklin, when he passed on at that point of time, he actually do not have a formal will. He passed on without a formal will. Okay. And then because of no formal will, then it create disputes among the family members. Okay. So initially, they think that she do not have a will. Initially think that no, do not have a will because they cannot find. Okay, so they say according to Michigan law, because Aretha is follow Michigan law. Okay, later I'll explain what is Michigan law. So according to the law, the estate will be distributed among his 4 sons equally. Okay, but months later, when they find dig, they found 3 handwritten will in her house. 3 handwritten will, 3 different years she wrote, appointing 3 different executors. Dated 2010, she died at 2018. So the will dated 2018 ma. So 2021, the last one is 2014. The will, handwritten will, is under his coach cushion. Just found under his coach cushion, the last one.
Oh.
But 3 will also different executor. So in lucky great disputes, disagreement, people say, among his family members, he said this will, this handwritten will has discrepancy, difficult to interpret. Then they caused dispute. Then end up, they went to court case because cannot determine which one is true, which one is not true. Because the first one maybe appointing one son, second one different son. So they want to favor which one? Or first son say, hey, no, the first one is true one. The son 2014 appointed one and said, hey, no, the last one. Then we go to court. So when they go to court, in the end, the court actually ruled that the 2014, the will which is under the coach cushion, is a valid will. So they exercise based on 2014 will. So from the Michigan law, right, they actually recognize informal will. Okay, even the will with scribbles, scratches on the passage, also they will recognize as the last command, so long this will is dated and signed. So this is for Michigan law. In the end, actually, because the court say that he ruled that 2014 that one handwritten, they can recognize one, so they go ahead for that. But actually, this legal battle and this ding ding dong dong went to court take for around 5 years.
Just to identify which will.
Yes. So, and during these 5 years, what can they do? They cannot do anything because when the things actually you go to court, you cannot distribute. You cannot distribute, maybe for Areca, the sons all have their own financial stability, they can have. But what if those who need this money urgently? If let's say come to legal battle also, they still need to wait. So for Malaysia, we see what is actually a valid will for Malaysia. This one is for Michigan. We are not living in Michigan, so we are not following Michigan laws. Okay? So for Malaysia, right, as a valid will, first we have to make sure the one signing the will, we call the testator. In some mind, mental not ill. If let's say today mental ill or not in sound mind, this will become not valid. First thing have to be in sound mind. Second and third thing is the same. When the testator sign, he or she have to sign in front of 2 witnesses. Okay? And when the witness sign to witness the signature of the testator, have to be in front of the testator. That means all the third parties have to be you see me sign, I see you sign to become valid. Okay? And then the witness have to be at least 18 years old. But for Sabah, it's 21 years old. But to be safe, normally I tell my client, although 18 years old, you ask 21 years old, better. Okay. But the content of the will can be written. We also recognize handwritten or typewritten in any language. But all the 5 have to be fulfilled, only we consider a valid will. And let me ask you a question now. Today, if let's say I, as a testator, I distribute my assets to my kids, both my kids equally. And today I say, hey, I don't have witness. I ask my children, come become my witness. Since you also benefit from the estate. Can my children become the witness if he or she as the beneficiary. Oh, clever. So clever, yes. So the witness cannot be the beneficiary. Otherwise, his entitlement, his or her entitlement will be taken off. He will be not entitled for the assets. So whenever people want to force you to do a will, to give to him or her, they say, okay, I do lah. You become the beneficiary to make the will invalid lah. So it's a very important point. As a beneficiary, you cannot be the witness. And to be safe side, normally I will ask my client, if let's say your husband or your spouse is a beneficiary, you also don't become the witness. Because end of the day, you will still, if let's say we want to argue, still can go to court, still subject to argument. Because it's your spouse. You better ask third party to do it so. Yeah. So if let's say today, for just now Arika, if let's say he don't have will, the asset will distribute equally among his 4 sons. Okay. But for Malaysia, if let's say today you do not have a will, we also have our own distribution act. Okay. Our distribution act is that if today you are leaving 3 parties, this one is no will. Okay, you are leaving your issue spouse and parents. So you can see from this one, right? The issue, which means the children, will get the most out of it. Okay, if today on the first scenario, all the 3 parties around, so the children will get 50%. Spouse and parents get 25% each. If today only issue and spouse, issue, which is the children, also get the bigger portion. Okay, spouse will get 1/3. Okay, and further on, you can see if let's say just left only one person, irregardless of spouse or issue or something, or whoever, they will get the whole estate. What I mean is that under this Distribution Act, the legal beneficiary will be issue, spouse, and parents. So it's either 3 parties also around will be the first distribution. If let's say only 1 party left, the whole estate will belong to him or her. Okay? And what if no one left? That means this testator, when he pass on, no issue, no spouse, no parents.
Got siblings or not? Auntie, uncle.
So if let's say no one left, right? This one is issue, spouse, and parents. Okay, the first layer. Is this layer all also gone? So we will go to brother and sister first. Then grandparents, uncle, auntie, great grandparent. That one also susah. If let's say grandparents also not around, okay lah, maybe uncle, auntie lah. This one susah already lah. If let's say this one still around, very good lah. Great grandparents. Otherwise, will be a gift to the government. Yeah. This Distribution Act, right, you see, this condition also will take place. Why is it sometimes the same thing? We are able, you see, when you see all the articles, right, you will see, this property, when you want to purchase, cannot change title. Why then? Because the beneficiary first, they don't know that maybe their parents or their grandparents have bought this land under their name. But because they don't write a comprehensive one, they don't list out their assets. Okay? So people, they don't list out their assets also, they don't know where they put their title. They will left out this property, this land, okay, this title. So when you want to buy, other people want to buy and say, hey, this property, this land, the owner also don't know who. Then left there, cannot buy, cannot sell, because we cannot locate who are the real owner. So second case, Tan Sri Jamaluddin judges who have followed his no lah. Never Tan Sri Jamaluddin Judges, actually he passed on during a helicopter crash in Malaysia, helicopter crash in the year of 2015. So he passed on untimely, right, due to accident. And then he is a prominent Malaysian politician and also a businessman. Okay, a well-known businessman also. He has so many business in Malaysia and maybe overseas. Okay, and then his untimely death, right? Actually, he created disputes within his family members because of the extensive assets, including the properties and also the business. So during after his demise, right? Actually, got a few lawsuits coming to claim. Okay, the first is actually the wife, the late wife, Wan Sri Carlson. Actually, she claimed on the matrimonial properties. Okay, joined with the husband, matrimonial properties, because Tan Sri is a Muslim, so they actually can claim for matrimonial property, which means when you when both of you married, and then after married you created so much wealth, this wealth, as a spouse you can claim back, but subject to court approval also lah. But you can make this claim because it's after marriage, you and your spouse created this wealth, you build them. Okay, so the wife will actually claim for this one, cost about 2 billion for only these matrimonial properties. Okay, second, the mother come into picture. Mother claim on the actually filed a suit against the grandchildren. The mother filed a suit against the grandchildren, claiming on the bank account, because the grandchildren is handling the bank account of this disease. So
it's Jamaluddin's children.
Jamaluddin's children. But the mother of Jamaluddin claim on the bank account of it because it's handling by the grandchildren. So he filed a suit. He also want the money. He also want some control of the bank account. So she filed a suit. And at the same time, she also filed a suit. He want to claim the rights of the company stake of this disease. The mother itself want to claim the rights of 3 of his business. So the things goes on and on. Until I think this fighting and this court case, right? Actually, recently they settled out of court. Recently they settled, but it takes 8 years. 2015 until now. Why is it 8 years? 2015 he passed on, and then I think the wife only filed a suit on 2016 or 18, something like that. And then keep on got some file suits coming in. They claim different items because so many items. So in this event, right, you see when a person pass on, just like this country, he passed on, he have extensive properties, he even have a business in hand. Without a will, it's actually create so many havoc, so many disputes. I would say that I will actually segregate this one into 3 different perspectives. From the distribution perspective wise, right? If let's say he do not have a will, the distribution of the assets may not be what he wants. Appointing a leader to lead the business, because no will, so you will follow Farid law, because it's a Muslim, they will follow Farid law. May not be what he wanted also. Right, not in the distribution. On a family point of view, you see, when as a family members from birth until now, we and our family members have created so many family bondings, right? Happiness together, just because of one event, and this bonding just splashed into the water. Because of no planning, no will, you didn't decide who to give to. So everyone is actually chasing. But you look back, is it worth it? Because from born until now, you are creating, you are building your relationship your family members, with your siblings, all so close, so friends, right? We go outing together. This relationship, because of no will, just not worth it. But today, if let's say you already know what will happen, or you already foresee because of so many stories that are coming in the picture, so we just do a will. We state clearly what do we need, who do we want to give to. Then it will make things clear. And for business point of view, just now we go for distribution, family point of view. And for business point of view also, okay, because he's running his business. If let's say he didn't appoint the executor, the one who did, so people will say, the founder not around already. So we do not know who to lead. So shall we continue to give them business? Correct? Shall we continue to have relationship with them, or we go for other company? No? And on the day-to-day operation, business operation, making decision, who are going to decide? We do not know. Because it creates power vacuum. Power vacuum means that we do not have a founder, we do not have a next to lead. Oh? Alright, is it too heavy?
Said sorry.
Okay, I think right now we will come to a break. Okay, we will break for 15 minutes. Alright, then we will continue for other steps too. Alright, break for 15 minutes, okay?
Thank you.
Alright.